mothers, the children who play and go to school with our children, the people we love and hold dear to us who are part of our communities. I can't thank you enough. As the son of Italian working class immigrants who came to this city of hope, more than a half a century ago, I don't lose sight of the fact, and neither does my family. Though, unfortunately, some people have, and we need to remind them why that hope and opportunity still has to be afforded to everyone who wants to be part of our communities and who loves this country as much as we all do. That being said, those values, as we all know, have been under assault. Democracy has been targeted and systematically being disintegrated, and all that we hold value and dear is in jeopardy. And now's the time not to sit and be silent, which no one in this room has been, or to be complicit, but to speak loudly, to be engaged, to advocate, to fight for, and to continue to fight, because in the long run, we will win. And you got my word personally, that's what I'm going to do, and I try to do every day. And I thank every single one of you, because all of your work, much of it goes unheralded. And thank our speakers for being here today, because what they do day in, day out, I admire them and what you all do. And I take my lead from your voice and your values and the people we fight for, especially those who are afraid to speak right now, who are sinking back into the shadows. We can't not let that happen or be the new norm. So on behalf of the city, and I welcome you here. I thank the speakers. I thank you, all of you, for what you're doing. I'm going to turn the mic over. Please excuse me. I have a couple other things I need to head out for, but I will come back. But I wanted to take the opportunity to say thank you and welcome. And I'm going to hand the podium off to the Director of Health and Human Services here for the city, Mr. Doug Kress. Thank you very much. I appreciate it.
Good afternoon, everybody. I'm Doug Kress, Director of Health and Human Services, and I want to echo a lot of the things the Mayor just talked about. I don't think I need a mic, but it's going to pick me up a little bit. If people do have an issue with hearing, please let us know. We'll make sure that we do use the mic, because we do have one here available, but it often gets a little clumsy for everyone. So we do want to make that available for people. We're also going to be sending around a sign-in sheet for everybody to just kind of give your name and address to help keep you informed of what's going on. We'll keep a small little private database available so that we have that, and we will check in with you and have that available if we have other information, and also we'll send out some other contact information that we're going to bring up a little bit later. One thing about Somerville, we've always been a community of immigrants from a variety of places. While the faces may change, we are still a community of immigrants. And that's an important thing to keep in mind as we look forward and why we're here today. It's always important to always think about who may not be able to speak up, are fearful of speaking up. And with today's, what's happening over the weekend, last week, everything else, we all kind of question, oh, that can never happen. And somehow it happens. And I don't know if you're like me, but I'm a little worried out there in this, and concerned. Although I'm going to continue to fight, and I fight hard when I do this, we need to come together a lot of times. The latest is that the public charge was actually on today, and public comments are now open as of today. We have a limited time period to make these comments, and we're thrilled that you're here today to learn a little bit more about what we're talking about with the public charge issues that are in front of us, what we can do as a community, what you can do as an organization, how you can go about doing that to make your public comments, and why it's important to make these public comments. One of the things that I always think about within this is that we don't want to have a form letter. And the reason we don't want to have a form letter is because they're going to start grouping everything together and respond to it as a large group. The federal government is required to respond to everything that they get. And if we just do a form letter, that's one thing they have to do. Let's make it a pain and let's make it hard for them. Let's make them understand the issues of what it means to be an immigrant. Let's make them understand what it's like to be here and being concerned about taking your kid to school, about showing up at the doctor's office, about getting food for your child, getting food for yourself, having a place to sleep. All those things are so critical. And we all deserve those things, everybody, no matter who you are, where you come from, the color of your skin, who you want to share your life with. It's all critical. So we're thrilled. I'm going to get off of my soapbox because I'm not the important one to listen to today. Thank you for being here today, all of our panel speakers. I'm going to help kind of moderate this a little bit. We have a couple other comments afterwards, and then we're going to leave try to leave a lot of time for question and answering. As everybody knows, there is some lunch out there. Make sure that you do eat. Thank you to the communications department for doing a lot of this work as well. Irma, Adriana, Jenny, Nancy from my office with the Office of Inclusion. It's always important to do all of those things. So thank you to all of them to also help getting all of this together today as well. So with that, I'm going to kick this off with our first speaker who's going to break down some of what we have in front of us for the proposed changes and what it means. So Sarang, do you want to take it from there?
Sure. So hi everyone, thanks for joining us today.
And raise your hand if you can't hear, and I will make him use the mic, okay? Anytime through this.
So it's really helpful if I give you a little bit of basically what I'm going to talk about today. This is stuff I know immigration lawyers. But public charge exists as one of the criteria for what we call admissibility into the U.S. So if you're applying for your green card, or you're applying for a non-immigrant visa, you have to be able to prove that you are admissible to the United States. You're not. We are in this language. Aubrey? Oh, there we go. All right. So you have to prove that you're admissible to the U.S. or else you won't be eligible to get that green card or that non-immigrant visa. It's also really useful, I think, to think of admissibility as the flip side of the same coin as deportability. If you are inadmissible or you are deportable, they can remove you from the country. Now, depending on how you are applying for a green card, that is what avenue you're going through to actually get the green card, public charge might come up as one of the requirements, one of the criteria when they're looking at admissibility. And generally what we're concerned with is with family-based visas and with any non-immigrant visas. Things like refugees and asylees don't have to deal with public charge. Cuban Haitian entrants don't have to deal with public charge. NACARA doesn't have to deal with public charge. We're really concerned with family-based immigration visas and non-immigrant visas, so like a student visa, tourist visa, something like that. So what is public charge? Public charge has been around for well over 100 years in our law, and it's changed very little over the years. The most recent change we had kind of tweak to it, really, was in 1999 under President Clinton. They defined public charge as in one of two ways, really. So the big question they're looking at, the overall question, is someone who would become primarily dependent on the government for subsistence. And in looking at that, they looked at a couple of things. They looked at where you're receiving cash benefits, so supplemental security income, temporary assistance for needy families, or any similar state-funded benefits. And they were looking at long-term care under Medicaid. Yeah, Medicaid. Long-term institutional care under Medicaid. If you received either one of any of those, you're considered public charge. The other thing they did, and I might be using past tense, keep in mind nothing's changed yet. So the other thing they do right now, I should say, is that they have what's called an affidavit of support. So let's say I'm a US citizen, I'm petitioning for a spouse to come into the United States. I have to file an affidavit of support showing that I can support my household, including that spouse, at 125% of the federal poverty level. And if I can get that affidavit of support in, that's pretty much the end of the analysis. There are other things they could look at, but if I have that affidavit of support, they're not going to bother looking, really. That's pretty much it. What this administration has proposed to do, there's a couple of major changes. So one is they're expanding the number of benefits that would count. So they're adding in SNAP, they're adding in non-emergency Medicaid, and they're adding in housing. Now they're doing this in kind of a weird way. I'm giving a very basic overview of what they're adding, but there's all kinds of calculations involved, both time and value of the benefit as well, to determine whether those count. The other change that they're proposing to make, which we think is frankly a lot more dangerous than adding these benefits in, is that they are no longer going to weigh that affidavit of support very heavily. What they're going to do instead is look for income at 250% of the federal poverty level instead of the 125 that it currently is. So if you're making below that 250%, even if you can do that affidavit of support, you're still going to have to do that affidavit of support, by the way. It's not going to count that. It's not really going to help you out too much. They're also taking a much broader view. So remember I said under current policy, if they have the affidavit of support, that pretty much does away with the analysis. Not so anymore. So they're going to be looking at things like your age. Basically, if you're not of working age, that's going to count against you. Your educational level, and in that they're specifically talk about English proficiency. So if you're not English proficient, that's going to count against you. They're going to be looking at things like, do you have a chronic illness? And if so, are you able to afford your own health care for that? So those are really just kind of the highlights or the lowlights, as it may be, of what we're facing right now. Now, the good news is we've known this is coming for a long time. Pretty much a week after the election, there was leaked to the media a draft executive order that was never actually signed. Then we saw drafts of this proposal come out this past February and again this past March. So we've had some time to get an idea of what they're looking to do. I will say that this isn't as bad as what we saw in February and March, but it's still pretty horrible. It's just not totally and completely mind-numbingly devastating. It's just totally and completely devastating. So we are working on a campaign to collect as many comments. Now that the proposed rule was published this morning, this opens up a 60-day comment period. I'll let Andrew talk more about some of the healthcare implications of this, as well as a little more about the campaign.
Great, thank you. So next up we have Andrew Cohen. Andrew is here from the Health Law Advocates and is just going to give us a perspective from the health area that we want to talk about.
Yes. Hi there, everybody. Hope you're enjoying your lunches, because that's going to be the best thing you're going to hear from me right now. Thank you, Sarang. I want to start by saying Health Law Advocates is a nonprofit law firm. We're based in Boston, but we serve people across the Commonwealth. And we focus on access to care and access to coverage. And if you know people in your community, or you have people in your families, or there's people that you work with who are experiencing legal barriers to care or coverage, you should send them to us. We help people who have private health insurance, as well as my expertise, which is public health insurance. So I want to begin by talking about a culture of fear that we see in the community. This is something that has existed in immigrant communities, for quite a long time. It certainly predates the Trump era. But in the Trump era, we've really seen a ratcheting up of this fear. I'm going to read you a headline from April 2017 from the Boston Globe. It says, "Immigrants, refugees, too afraid to seek critical help from food pantries and domestic violence resources." So there's a couple things I want to point out about this headline. The first is it talks about immigrants and refugees, okay? When it comes to public charge, just as Sarang was saying, refugees are not implicated. They do not have to go through the public charge test. And in fact, as Sarang was saying, there's a whole number of groups, particularly these humanitarian statuses, that don't have to face the public charge test. Nonetheless, you see refugees being scared to access vital help. And so the other piece I want to point out is critical help from food pantries and domestic violence resources. neither food pantries nor domestic violence resources are included under this public charge rule. So really what we're seeing here is the chilling effect of the rhetoric that we get from the federal government and these kinds of rules and the information about these rules and, quite frankly, misinformation about these rules that spread throughout communities. So I'm going to do just another very quick kind of overview of the rule just to pick out a few critical things that I see in this rule, although I think Sarang did a terrific job giving the overview. The first thing is this is a more restrictive test than we've seen before, just as Sarang was describing. And we're talking about not all different kinds of statuses who have to go through this more restrictive test. It really is people who are applying to get their green card and people who are applying to get immigrant status or non-immigrant, immigrant visas or non-immigrant visas. So if you already have your green card, it doesn't affect you. If you are a refugee or an asylee or special immigrant juvenile status, these are things you're applying for and trying to get. You're not going to go through the test. Second, as Sarang was describing, it's a totality of the circumstances analysis. This is something that has existed again prior to this new rule, but just as Sarang was saying, there's all these different factors that they're now weighting in a different way. And the key point here is that it's highly discretionary, all right? People who are going to be making these decisions about whether people are public charges, whether they can get their statuses, whether they can get their green cards or get their visas, these folks have a huge amount of discretion in terms of determining whether they're going to give this visa based on these tests. Next, a key point about this rule is it's kind of a secret about this rule because the way that people were talking about it before and the way that it was framed in the prior drafts of this rule is slightly different than what is actually in this rule. We're not really just talking about a retrospective look at whether people have benefits. That is in there, and they will be doing a retrospective look. But even more important than that retrospective look of have you gotten benefits is the prospective question. Will you get benefits? And so this piece of the analysis, as I mentioned, highly discretionary. The idea is, will you at some point become a public charge? And that is where we're really afraid around how it's going to impact families. Because even if people don't get benefits, if they earn income in a range that would get them access to benefits, or maybe they would get their green card and then have access to more benefits, if the question really is, could you get benefits? Are you going to be a public charge? They can deny, even if you haven't gotten benefits. All right, there is also these new draconian income requirements, as Sarang was describing. If you earn under 125% of the federal poverty level, that's a highly negative factor. If you earn above 250% of the federal poverty level, that's a highly positive factor. So really, the income piece is key when it comes to the public charge prospective analysis. And again, I just want to reiterate, it's not really just about public benefits and access to public benefits or even being in public benefits. It's also about what's your income? How much do you earn? So in that sense, this is really a policy not just targeted at people getting benefits, it's targeted at low-income immigrants across the board. And I do want to say low-income immigrants of color specifically, because this is a racist policy. I also want to reiterate that this does not apply to many categories of immigrants, and I've already talked about that, but it's really important to understand there's a whole lot of people who it doesn't apply to. So not only does the public charge rule have these income requirements and include certain benefits but not other benefits, they also make presumptions about people's ability to work. So they talk about age. If you are under 18 or above Social Security retirement age, 65 or 66, 67, depending on who you are, basically there's a presumption that you may not be able to work and be a productive citizen. So let's just sit back and think about that for a second. Children under 18. Are children under 18 supposed to be working? I mean, certainly some have jobs, but honestly, let's talk about a 7-year-old. I mean, this policy is kind of ludicrous when it comes to weighing the age factor, and that's just one example of how the rule is quite problematic. But also, Sarang mentioned health status. If you are sick and you have a diagnosis and you don't have private health insurance, that's a heavily negative factor for you. So if you're an immigrant that might have some kind of diagnosis, let's say it's a cancer diagnosis, or let's say diabetes or something like this, and you don't have private health insurance, you could be considered a public charge regardless of whether you have benefits now. Now, when it comes to health care, I'm going to dig in very briefly to the health care program. So the first program that is included under the public charge regulation is Medicaid that is non-emergency Medicaid. For people keeping score out there, in Massachusetts, our emergency Medicaid is Mass Health Limited. So if people who have Mass Health Limited, it's not counted. Okay, you can have Mass Health Limited. However, if you have Mass Health Standard or Mass Health Common Health or these other kinds of Mass Health that are comprehensive Mass Health, that can count. The other thing that can count are subsidies under Medicare Part D. This is often called extra help, or it's often called the low-income subsidy or LIS program. So if you qualify for that program, again, you could be considered a public charge. So what doesn't count? Mass Health Limited, emergency Medicaid, tax credits under the Affordable Care Act. So in Massachusetts, that's Connector Care. That does not count. You can get those tax credits. CHIP right now doesn't count. That's the Children's Health Insurance Program. It's kind of a Medicaid-like program, but it is distinctive. But in Massachusetts, it's all included under Mass Health, Medicaid and CHIP. So you actually can't distinguish what you have. But CHIP currently isn't included, although they're considering including it. So we need to be speaking out against including CHIP. But the other thing that's not included are state and local health care programs. So things we think like the health safety net wouldn't be included, or programs like the Children's Medical Security Program, or state-funded, fully state-funded Mass Health, we assume, would not be included. So here's an interesting takeaway that we're not necessarily thinking about when considering this rule. I just listed what programs were included and the ones that weren't included. And we talked about the kinds of immigrants in which statuses are included and which statuses aren't included. So the question is, who has a status who can get access to these included programs who would be subject to public charge in terms of the benefit piece solely? The answer is very few people. Almost all of the benefits that are included require a green card for more than 5 years. They require you to be a refugee. They require you to be an asylee. They require you to have one of these statuses that's more robust and actually gives you access to these benefits. So the answer is there are very few people, except these very niche populations, who would actually be in the benefits that count now. So this whole thing about people not wanting to be in benefits is really deeply problematic and kind of a red herring in the sense that people should not be dropping benefits. Actually, the number one, there's one takeaway from what I'm saying here today, the message to community is don't drop benefits now. It's not going to help. And in fact, if this even goes through the way that it is framed, dropping benefits probably wouldn't help then either because of the income piece. Now, even if you're in benefits, you have to have a certain income level to be in those benefits. And if you're in that income level to get into those benefits, you're probably under the income level you're probably within the range, under 250% of the federal poverty level, where they're really thinking, your income's not so good, you may not be able to get the status. So the real point here is, in terms of messaging, stay in benefits now. There's no reason to drop benefits, okay? Number two, the rule just came out today, but it's not in effect. The rule's not in effect. It's going to be months and months and months for it to go into effect. And with lawsuits that my friends at Lawyers Committee will talk about, it's possible that could be even held up more. We shall see. The point is, we don't know when it would take effect, and we don't know even what it would look like when it does take effect. So stay in benefits now. It's not in effect. And third, we are fighting back, all right? So how are we fighting back? Sarang spoke about the comment period. So that's the first way. We have 60 days from today. I think it's either December 9th or 10th. I haven't done the calculation. I've actually seen both. That we have 60 days. What, do you know exactly what it is?
It should say it in the reg. Let me take a look.
Okay. So Sarang's going to look that up. Yay, cell phones. But we have 60 days to provide comments, and we need all different kinds of comments. We need comments from community members telling their own personal stories. We need comments from family members saying, this is what's going to happen to my family. We need comments from city workers saying, I serve people in the city of Somerville, and this is what's going to happen in our community here. We need each of your perspectives. We also need nuanced comments in the sense that they're more technical. We need more technical comments as well. And I sincerely hope that there'll be multiple people within the city of Somerville in different agencies within the city who will write technical comments about how it will technically affect the populations who live here in the city. We're talking about, taking some data and trying to understand data in the context of this rule, looking at laws and local ordinances, all of these things. How is it going to affect from a more technical standpoint? But we need both kinds of comments. What we don't need are comments that are just the same. Okay? It's better to have a short comment that's unique than an extensive comment with, all fancy language that are all the same. All right? So in terms of doing comments, so I'm with MIRA Coalition, Health Law Advocates, my organization, Healthcare for All, in the Mass Law Reform, are four organizations in this, what's called the Mass Protecting Immigrant Families campaign. This is part of a national PIF, Protecting Immigrant Families campaign, and we are all moving forward in Massachusetts, trying to help folks like you and your constituents to be able to put in comments. There's going to be comment writing parties. We do hope that the city of Somerville holds a couple of comment writing parties to bring people in, community members to write comments. And we will be providing resources, and there will be resources provided at the national level too that we can use. The other thing is there's going to be popular pushback. We need rallies, we need good press. Although we don't want to be scaring people. So that's kind of the key there too. We don't want the message to be, you should be afraid. We want the message to be in benefits. And it hasn't changed yet, but we need to fight back, okay? So it's kind of a nuanced message, but a really important message. And we can talk more about ways that we're fighting back in question and answer.
Great, thank you. Sometimes I was getting excited about it. Sometimes I was getting nervous what you were saying. So maybe others were feeling the same way. It's like, oh, this maybe not so bad. No, that's bad. Oh, this is bad. No. So we'll have question period towards the end. Are you going to speak together or pass it back and forth?
We'll
between
do
you
half
guys?
and half.
Great. All right. So we have the legal perspective and challenges, and we have Evan and also Oren here who are going to be here to give us a little bit more information on that.
Great. Yeah. So thank you for having us both. I'm really excited that Somerville City Hall is putting this on. I'm a resident of Somerville, and so it makes me really happy that my city is actually taking this seriously. So I'm going to provide a dose of misery and then also a dose of hope. I'm going to talk about kind of the current landscape that we're seeing and how this fits into the push, the anti-immigrant push that we've seen before this administration and that we're seeing much more forcefully during this administration. And then I'm going to talk a little bit about some of the hopeful things down the line, what the fight looks like through notice and comment and then into potential litigation. And then I'll turn it over to Yvonne to talk a little bit more about the broader policy perspective that we're seeing here. So what we've been seeing at the Lawyers Committee since, particularly since the beginning of this current administration, is an intense anti-immigrant push against immigrant communities across the board, particularly immigrant communities of color. I think it's important, like Andrew was pointing out, to note that this law and the other policies that we've been seeing are particularly targeted at immigrant communities of color. It's not the 90,000 undocumented Canadians that are hanging out in Wisconsin that are going to feel the brunt of this policy or the other policies. Some of the things that we've been seeing are policies aimed at incentivizing ICE officers to stock our state courthouses, which is making immigrant communities feel afraid to access justice and access court resources. Another thing that we've seen is a citizenship question added to the national census, which is making people feel afraid to participate in the census at all, which could result in immigrant communities in particular getting less federal funding because they will be undercounted by the census. We've also seen agencies like the RMV denying licensure or commercial driver's licenses to immigrants whose status might terminate in the future. And so we've seen all of these little programs that cohesively altogether seem to be the federal administration trying to make life unlivable for immigrants in our communities, and trying to make it much harder for states who would like to have a higher threshold of services that they provide to immigrant communities, trying to make it harder for those states to actually administer those efforts. What we saw back in 2017 is the Trump administration actively target Massachusetts, for example, for immigration raids because of some of our sanctuary city policies, both in cities like Somerville and Chelsea and Lawrence, but also because of rulings by our highest court that said that local officers aren't allowed to arrest immigrants solely on civil immigration matters. And so that's kind of the context that we're seeing. It's a context of anti-immigrant movement, but it's also a context, like Andrew was saying, of intense fear. That there are real concrete policies that the federal administration is taking against immigrant communities, but there's also a huge shadow of fear that's cast much further than those policies. This is one of those policies. Like Andrew was saying, this actually only affects a small subset of immigrants. It's going to be very important for those people, but it is casting a pall across communities. What we've been hearing from community partners is that people are already going off of benefits and are afraid to go on benefits. And like Andrew was saying, that's not that much help. Benefits are life-saving resources that people need, and also going off of the benefits actually won't help that much. But there is this culture of fear. So that's the dose of misery. Now, to fight back against that, I think one thing that's important is what we're doing here. You know, we're having this public conversation, we're doing public education, and so people can know that even though there is this push against immigrant communities, the fear sort of is only exacerbated when we kind of take it and run with it. So, you know, like Sarang and Andrew were saying, that's, you know, step one. Step two is engaging in the public notice and comment period, making unique comments, and really telling, you know, what the impact of this policy would be to you, to your communities. Talking about, you know, how it would affect health, how it would affect schooling, how it would affect housing, how it would affect sort of the racial makeup, and, you know, really getting at what are the racial and economic discrimination that are embedded in this policy. So that's the notice and comment period. Hopefully it doesn't get anywhere beyond that, but that hasn't been our experience so far. So once it does get beyond that, then the next step will be to continue to fight back, you know, rallies, media, public education about who is covered by the policy and who is not. One other element of fighting back is what we at the Lawyers Committee and a number of other groups are considering, which is fighting back in our courts. Our courts, thankfully so far, and particularly here in Massachusetts, have been a pretty good bulwark against the Trump administration's immigration policies. At the Lawyers Committee, for example, we've had success challenging the termination of temporary protected status. We've had some success challenging, oh, thank you, challenging infringements on the funding that goes to sanctuary cities like Lawrence and Chelsea, who we represent. And so we're hoping that if this policy does get to the point where it needs to be challenged in court, that our courts will again act as a safeguard against this particular type of overreach from the federal government. Some of the challenges that we're considering are also important to note because those are the types of things that you might want to comment on. Things like the way that it will prevent states and cities from enacting some of their local policies effectively, particularly in the healthcare context. Also, if we were to bring a challenge, it would likely be around some of the racially discriminatory elements of this. Like Sarang was saying, this applies, one of the factors is whether English is your first language and whether, that's a particular target. What we've seen in the TPS case, for example, in documents that were released publicly, is that the Trump administration targeted Haitian immigrants and had the Department of Homeland Security search into Haitian immigrants who either had criminal records or who were on public benefits, and that was part of their assessment of whether they were going to cancel temporary protected status for Haitian immigrants. So there's no question that this is a racist and discriminatory policy, and that it will likely be part of our lawsuit, and luckily the courts have been good at taking that and understanding, what the intent is, what the context is behind these laws. But that understanding is also important at this point in the movement to express why that's a problem and to express that it is a problem and to put that in the notice and comment period as well. So I'll turn it over to Ivan to kind of expand on that.
Thank you, guys. My name is Ivan. I work with Ora Nimni at the Lawyers Committee. And as I was hearing my colleagues speak, I actually did some really quick math. So right now, the poverty level for a family of 4 is roughly $25,000. So under the current existing immigration policy, right, that evaluates families at the 125% level, that means that for a family of 4, that family needs to make roughly about $31,000, $32,000 to be able to qualify for the immigration protection and relief that they're requesting through family petitions and otherwise. So it's already a little high, right? You can't be working in a minimum wage job and applying for a green card even under the existing law. And what the new law that my colleagues are talking about, that $32,000 is going to shoot up to roughly $63,000 to be able to get a green card if you're living in a family of 4. That is well above what a working class family in low income communities makes. And so when we're talking about these percentages, right, we're talking about things that are going to affect the very lived experience, the lived reality of people in Somerville and many other communities. Because $63,000 is a lot of money to make if you are a low-income immigrant family. And so what this is doing is essentially presenting a financial litmus test to be able to qualify for a green card. There is no way around that. And it essentially, and I think this dovetails with the litigation that my colleague here is talking about, it is using this financial litmus test, this public assistance litmus test, as a proxy for race. Because you better believe the families that are making less than $63,000 are disproportionately Black and Latino immigrants, right? So I think that provides us with a very strong constitutional hook to be able to say this policy is intended to go after Black and brown families and to exclude them altogether from the immigration process, particularly with the extremely onerous financial requirements. And that's just for a family of 4. From there, the numbers skyrocket, right? So family of 5, family of 6. I didn't run those numbers, but you better believe they're well into the 60s, 70s, and $80,000 a year. So that is one legal hook that I think is really important and for all of us to keep in mind, right? The real numbers that this is affecting. And the second thing, and with that I'll close, I want to build just really quickly on something that Andrew was mentioning, which is Andrew used the example of diabetes, which is something very, I would say routine. This is something that in many families is present, right? And if you present with diabetes as you're going through these immigration proceedings, you better believe that the feds are going to ask you, how do you intend to pay for your treatment? Because we will not fund it, right? And so we're talking about creating exceptions for significant medical conditions. Diabetes, I think, is a low-hanging fruit one. From there, we can continue talking about even more expensive medical treatments. People who need treatment for hepatitis, which is extraordinarily expensive, much more expensive than diabetes, and HIV medical care and treatment. We're talking about conditions that are long-term expenses that present significant medical needs, and that the medical service is critical. You need access to that life-saving medical care and treatment to be able to live a regular, normal life like everybody else. And so then one of the other areas that we're concerned about is not just the financial and racial implication, but also the exclusion of entire populations that are living with certain conditions, some of them, like HIV, considered disabilities. And as we all know, right, we all need to keep in mind disability accommodations as we go through our work, whether it's what's access to City Hall, what are access to the services that we provide, how are we making sure that we're not discriminating and that we are doing everything we can to be accessible and relevant and responsive to the needs of people living with disabilities. Well, this policy, what it does is that it creates a big exclusion for exactly these vulnerable populations that we have all been working for years to be able to treat better and be able to be more responsive to. So the exclusion of, I would say, protected identities and conditions presents huge legal problems in the rollout of this particular policy. So with that, I'll just say that I feel like we already have the laws in place to be able to address the public charge concerns that my colleagues were talking about. Those laws are already in the books. We don't need anything else, and I think that should be an important part of the messaging through the notice and comment period. And we need to make sure that as we're going through this process, we keep these particular sensitivities, whether it's the onerous financial requirement, the connection to race, which is not attenuated, it is quite direct, and the connection to disability discrimination.
Great, well, thank you. Let's give them a, that's amazing. Thank you all. So I think one of the comments that was made is, what are we going to do here in Somerville? And we are going to be making comments that are through the city itself, but we also need all of you to do that as well. But we know that sometimes we need some additional assistance. So I'm going to ask just a couple of our staff, Irma, if you could talk a little bit about some of the tools that we might be able to offer to some of the community members. And then I also have Kate Harkey here from our grants department who will also give a couple of comments as well.
Thank you, Doug. First of all, I want to say thank you for being here, taking the time to learn about this awful public charge law. Rule, sorry, and but I think we need to educate ourselves and our communities as well. And I just want to make sure, as a city of Somerville, we can provide the tools you need for the public comments. So unfortunately, Emily Monea, who is the Somerset director, she can be with us, but we are putting some city staff to help with the public comments. So giving us tools if you need some data. So Somerset staff can help you with the data you need to make your comment really accurate. And we will have the support of the Grant Development Department, and Kate is here. She will talk a little bit more about that. And we didn't have the conversation, formal conversation, but we were planning to have some community meetings just to send that message. People doesn't have to leave the benefits right now. So, I think that's all. If you have any question, you can call Somerville. Yes. Oh, the comment tools, we are working with New York City to put in our website this link. So you don't have to go to the federal site to put in your comments. So we will let you know when that is ready in the Somerville page, and you can just link there and send the comments. And Kate will talking about how they can help.
Sure. Good afternoon, and thank you everyone for joining us to talk about this very important subject. We're glad you could all make it today. My name is Kate Hartke, and I'm the director of the Grants Development Office. You've heard a lot from Andrew about the tools and resources that will be provided to you as you begin making your responses and crafting your comments in response to the public charge changes. But the City of Somerville can also offer some select public comment tools because we're concerned about the community-wide impact that this may have on Somerville and throughout the area. If you need a fresh eye review of your response while you're writing it, please contact me. I can't write or edit your statement, but I can certainly review it in terms of coherence and clarity based on what you're trying to say, and make some suggestions if anything is unclear. So my cards are up here on the table, and please let me know if you would like to talk further. Thank you.
Thank you, Kate. Let's take a couple of questions from the audience, if anybody has any.
Hi, thank you for coming. So I'm a little confused about one piece. What we were hearing is if people are already here with a green card or a visa, that they should...
So we have you in.
Absolutely.
If you don't want to be on mic, just let me know, but I know Kathy will.
Okay, thank you. So my confusion is if someone's already here with a green card or a visa, we were hearing that they should be concerned if they want to further and apply for citizenship that these rules could affect them. And you're saying, I see a no shaking head. And if I could add my other questions, SNAP doesn't appear to be on the list anymore, is that true? No. It is on the list, okay, I didn't think I heard that one. And then for people writing affidavit letters of support who are here, we also heard that the public charge pieces could be held against them if they're writing a letter of support. If they ever accepted a benefit, that would be true then, right? Okay.
There was talk of going after people who write affidavits. And that is unclear yet, whether or not the feds will actually do something like that moving forward. It's something the feds have never done before. They have never gone back and seen, oh, well, you know, Oren submitted an affidavit for me, and eventually I received some type of public assistance that counts, so now we're going to go back to Oren and charge him for those benefits. That is unheard of. That has never really happened, as far as I am aware, and I think most advocates would agree with me. But that has been an area of some. We don't have clarity yet on whether moving forward, people who sign affidavits will be held accountable if there are some public assistance that is used to buy an immigrant down the line. But I don't know if folks want to comment more.
So there's actually something else in the rule that we didn't talk about that takes up a large percentage of the rule itself, which is surety bonds for folks who are green card holders. That these bonds that if, in fact, people are going to be a public charge, and they are basically adjudged, yes, we think you're going to be a public charge, but you don't necessarily have some of the really negative factors, then they can allow people to take a surety bond of at least $10,000. And so these bonds, I'm not an immigration attorney, so maybe Sarang should step in here, but these bonds basically already exist, but they're trying to, it seems to me, expand the use of them. And so this opens up a whole nother question about, the bond industry is, I'll just say, known for having some unscrupulous practices around collection of bonds. I mean, you think of bail bonds. I mean, this could be a similar thing here that we see, that people who are now going to have their green card, they now have at least a $10,000 surety bond. And how is that going to be collected if they then get benefits? I mean, so there are a lot of questions that we have about the way this is going to operate in practice.
And then I guess we're working backwards. So your first question about citizenship. So there were a lot of incorrect reports in the media about a month or so ago saying that this does apply to people who are applying for citizenship. It does not. Under the law, this is not something the administration can even change. That said, nothing's ever quite that simple. So there is a provision that says, let's say you have a green card and you travel outside of the country for 6 months at a time. When you're coming back, you are now applying again to be admitted. So you could see it kick in those kind of situations. The other piece, which actually wasn't included in the rule as it was published today, there is a section of the law that for people who have already been admitted, let's say you get your green card, but you become a public charge within 5 years. There's a provision in the law which, like what Yvonne was talking about earlier, has almost never been used, but it does allow for the deportation of folks who become a public charge within 5 years of getting their green card. We were expecting a piece about that to be included in the rule. It was not. That said, there are some rumors that this could come out later through the Department of Justice instead of Department of Homeland Security. So that's another piece that we're keeping our eye on.
My name is Fatu Drami from Riviera. I have been getting a lot of calls and concerns from people that I work with and people that I know about. Their concern is that those whose applications are already in process to become green card holders, is this going to affect them if the rule is rolled out? Are they going to be affected?
So for people who have green cards in process, I guess the answer depends on at what point it comes up for their interview. So for instance, this rule's not in effect now, right? The other rules, the old version, which is still in effect, will be in effect for quite a while. And so if their interview comes up, anytime before the actual rule comes out, it's going to be the old rule. If it comes out, if they have their interview in the future, far in the future, and the rule has come into play, then they need to be concerned. But it's not backwards looking when it comes to benefits that people get before the rule is actually promulgated. So I'm going to say that in a different way. People who get benefits now, they're not going to look at those benefits in terms of considering people a public charge. They're only going to start looking at benefits, I believe, 60 days after the rule comes into effect. So people will have 60 days to disenroll, earn more money. There will be a look-back period, but it's only going to start 60 days after the rule comes into effect. So get benefits, all right? Get them now, continue to get them. The only point at which you have to worry is 60 days after the rule takes effect.
And they apply for the benefits. Is that still like health, the health benefit? They should just go ahead and do it.
It's so important, particularly pregnant women, but really for anybody that has medical conditions or pregnant or something like this, you need benefits, get benefits. There's no reason, there's no good reason to quit your benefits now if you're not enrolled in benefits now.
Thank you.
Really, that is the message. Get benefits.
Hi, good morning. I'm Ellen Schachter, and I work at the Office of Housing Stability here in Somerville. I'm a little encouraged by something Andrew said about state-funded health care, that I'm hoping the same thing might apply with housing, that they're only looking at federal housing programs, and hopefully that doesn't happen to any extent, but if it does, and I guess I want to know if that's correct, and then if it is, it leads to me to be thinking about in the future whether or not we ought to be looking at a policy angle of saying that people in federal housing would have a right to transfer into state housing. But
Unfortunately, none of us are housing experts up here. That said, they do specify, I forget what it is, they do specify Section 8 housing, and they specify another piece of housing legislation that I'm not familiar enough with to know if that covers state or not. Most of the stuff they talk about that they've added does not count state funded, but folks are still looking into it.
Pat Baker and people at MLRI who are housing experts have basically looked at the rule and said the only people who qualify for these programs already have their green cards for more than 5 years. So in those cases, what's so funny about that, though, so there's certain circumstances with mixed status families where they actually may be living in public housing. But actually, I think the way the money flows is that person is technically kind of excised out of the amount they receive. And again, I'm not a housing expert, but I'm just saying what Pat Baker told me. But essentially, and you should talk with Pat Baker, but basically she's not concerned. And just like I was saying about what I do have expertise in Medicaid, there are some people in Medicaid, but very few people who are actually in the benefits who are going to have to go up against this public charge test. I think that's true in the SNAP context. That's true in the housing context as well, as far as we understand. And again, it really is the income, more bright-line rules that they are issuing under this rule that are probably much more problematic for people than these programmatic inclusions. That said, what Sarang was saying about this deportation piece that has not yet been issued, maybe it will be issued by Department of Justice, maybe it won't, maybe it will, who knows, we have no idea. But that is potentially on the horizon.
And just to piggyback onto the last thing that you said about whether you should be sort of advocating a transfer from federal housing to state housing, I think it's not I won't say with 100% certainty that this policy won't affect the way that some state programs work. I think it's unlikely, but I wouldn't say that with 100% certainty. But as far as what can we advocate going forward, state and local policies that operate on their own legs are, I think, good ways to avoid this kind of federal overreach.
And actually, the issue that you bring up about this mixed status households, that's a perfect thing to put in comments, right? It's a more technical point about how it's going to create problems for, I'm not a housing, but state or even city housing. And I think that's really important to bring up in these kinds of comments.
Thank you. I'm Sylvia from Revere. In terms of the TPS status, which I know right now it's in process to hopefully to get a more permanent status, would it be considered a humanitarian path? Because otherwise, in the public charge rule wouldn't apply to them then.
Yes.
Yeah, I would say, most likely yes. But that said, it would require a statutory change, so Lord only knows what Congress is going to do. But pretty much all humanitarian statuses right now do not include the public charge, so that's why we would most likely say yes, but I can never put any guarantees on anything.
So just one slight nuance is that if you're applying for TPS, definitely doesn't count under this rule. Okay, if you're applying for TPS. But if that TPS person now is applying for a different kind of visa, let's say they want to apply, I'm just making this up, let's say a student visa, it would count if they're going for that student visa. All right, or let's say somehow they get a pathway to a green card from a family member and they're applying for a green card, then it does count. So it depends what status you're applying for. In TPS, if you're applying for TPS, it doesn't.
Hi, I'm Mary Casesso. I work at Cambridge Health Alliance and live in the city of Somerville. The question, it's not so much a question as, is the intention that you'll produce a one-pager or a back and front? Because many of us were furiously taking notes. Once we leave you, they might not make as much sense. And many of us are representing our organizations and want to put out some public information to start garnering support for some of the letters, et cetera. You mentioned healthcare, and many of our providers want to do exactly that. But I think if we all had consistent and as clear as it can be bullets, it would help, because I can't help but think that some people, immigrants, just because it's overwhelming and because it's been just such a culture of fear, that it's almost easier, no matter what we say, to just not get the benefits because, oh my gosh, it's just confusing. Thank you. And appreciate all you've done and said, too.
So the Mass Protecting Immigrant Families campaign, which MIRA Coalition and Healthcare for All and Health Law Advocates and Mass Law Reform Institute are a part of, we have developed a number of one-pager, two-pager type documents. In fact, there will be one that's distributed later today to this broad network of groups. I think there's over 200 people on the list. But if you want to, get access to this stuff, email Sarang or me or the other folks from the Protecting Immigrant Families Massachusetts campaign. And there are some really good materials that we have, but there's also really good materials at the federal level that are, if you go to protectingimmigrantfamilies.org, you can get access to tons of materials, including folks in other states are developing more localized materials as well.
So, Mary, so you don't have to write that email down because I know that you didn't quite catch everything, or anybody else. We will, if you did sign up, we will send out some of this information as well, along with some of the things that we are looking at for those one-pagers. Who has the clipboard for sign-in? Okay, I think it needs to come back up this way so we can do that as well. Did you want to add anything else to that, Irma? No, that was enough? Okay.
Can I just say one other thing? We're going to actually have a phone call tomorrow at 3 p.m. to do, it's kind of similar to what we're doing here, an overview of the rule and then talk about the comment strategy. But for folks who weren't here, or if you want to, just have another refresher, join that call tomorrow. Again, I don't have the call information right now. We will be sending it out from the campaign later today.
And we'll send that out if you sign up.
Hi, my name. Hi, I'm Ruth Farris. I'm a social worker in the city. I just wanted to ask, is there any level of elected official where some pressure can be brought to bear in this time? The 60 days will span the midterm elections, and, where is there any possibility for help?
Sorry about that sigh. As a general matter, I think pressuring your public officials is always a good idea. I think you can pressure them on the local and state level to create programs that will protect immigrants more holistically in a number of different ways. On the federal level, since you mentioned the election, everything is always open to new statutes and statutory change, and it would be great to have laws that made, public charge even better than it was previously. So there is pressure, and I think putting those specific pressures on elected officials. I mean, this is an administrative rule, so there's less access for this particular thing, but more pressure is always better.
I'm going to add one other comment to that. And I think one thing we have to keep in mind is we're in a very liberal state, which is nice. It's great to be here. I came from one of those as well in Minnesota, for the most part. We also have to remember there are a lot of other places that are not elected and people who may be as open to some of these things. So how does that happen? I know I probably shouldn't say that, but I'm going to say it. Other comments? Questions? You can use that mic right there.
So I just have a quick question. I know that previously there was a concern that if family members were receiving benefits, that was going to be weighed against the petitioner. I'm wondering, it doesn't sound like it's part of this, but I would like clarification.
I always give the qualified answer. So, yes, in previous versions, previous drafts of this that we had seen, it was specifically mentioned that when they're looking at the totality of the circumstances, they would look at, well, were other family members getting benefits as well? They do not include that in this version of it. However, as Andrew was talking about, it's a prospective look. It's looking at what's possible in the future. So I am not entirely confident. My concern is that they're going to look at, let's say we are talking about that mixed status family in Section 8 housing where it's U.S. citizen children who are receiving the benefits. The parents aren't. Well, are they going to look at that and say, well, this makes it more likely that the parents will receive those benefits as well? So that's my concern.
Sense. It's not the retrospective, were you getting the benefit? It's the prospective, now that you have that status, you're now going to get into Section 8, right? That's what they're going to be thinking about.
So my question is, I'm Liz Peck, I'm with Homes for Families. My question is, if you become a public charge, is that how you would say that, first of all, if you become a public charge, and so you can no longer then become a citizen, what else happens to you? What else could happen in sort of a more immediate sense? What else could happen? Like, what kind of list are you then being put on that could lead to other consequences for you, your other family members, aside from no longer being able to become a citizen?
I think that's a really great question. And what we've seen over the last few years is this tendency and trend towards the criminalization of immigrants. And so your question reminds me of some of that, how immigrants are being rounded up. There are many barriers, right? Even immigrants. We've seen news of married couples who go in for a green card interview, and then the husband or the wife get arrested by immigration at the interview where they're supposed to be getting legalized. So we've seen a lot of this, I think I would say, is cruel type of immigration enforcement. And so I think you are raising a very good question about what happens to someone who's going through the immigration process, and then they say, oh, you don't qualify for a green card because you participated in public assistance, or you're participating in public assistance, you're a public charge, or whatever technical term they want to use. Well, what happens to those people? And I think that is a big question mark, and that is precisely why we need the comments that you guys are writing. We need the elected officials that were mentioned about taking a position against this. And we need litigation to be able to ensure that this does not move forward. Because right now, we are just at the beginning of this process. And how this continues to unfold and affect the lived experience of people in our communities and who we serve in our organizations is yet to be seen. And frankly, I don't want to know what the answer to that question is under this administration. And it is critical that we continue to do this advocacy, each of us from the perspective that we're in, whether that is submitting a comment, taking an organizational stance, calling our elected officials, and at the Lawyers Committee for Civil Rights, that means litigation so that we can put a stop to this on its tracks.
Just to add one thing to that. So there's another recent change that this administration has made that's kind of flown under the radar, which is, and this went into effect actually last Monday. If you submit an application with USCIS, and let's say I'm undocumented, I'm applying for my green card, my spouse has petitioned for me, I submit my green card application, that now gets denied because I'm considered a public charge, I'm now inadmissible. They're automatically going to be referring me to immigration court now. This is going to be an automatic process for anyone who files an application with USCIS and is found to be removable from the country. If denial of your application leaves you without any kind of status. So that's another big piece of this that we're unfortunately looking at.
Any other questions? All right, we'll be around for a couple of more minutes afterwards, but I think, I want to say thank you again for taking the time to come over to Somerville and do this work for us. We are a great city. It's a great city to live, work, play, raise a family, and age in place, and we want to continue to do that for everybody. So that's an important piece. I just want to quickly review. I think I heard a couple of different things. One, get your benefits, stay on those benefits, don't give up those benefits. Second is it's about unique comments. It's not those form letters. It's not all that detail. It's about, even if it's short, make those unique comments. Those unique comments are critical for us. We need to think about how do we educate everybody about this? What are the facts? What are the myths? How do we make sure that the education is out there? And then finally, we need to mobilize. And how are we going to do those mobilizations and continue to do that and build that and bring a friend along, bring 2 friends along, bring 10 friends along, bring 20 friends along, bring family along, everybody and anybody that you can think of, I think is an important piece of that. So thank you for those points that we have. Lastly, I just want to kind of go over a couple of other things. The city is here to help. We're here to help with comments, whether that's accessing some data. If you need any assistance with that data, we will not write these letters for you. We cannot do that. You need to do that. Those are the unique situations we want everybody to submit. That's an important piece of that. How do we do that? But if you need some help looking at data, if you need some help with clarity information on that, we have Kate and her staff that are willing to do some of that work, which is Laura right over here as well, so thank you. Kate's cards she's gonna have them, there'll be some up front as well. We also have talked about the things that Irma is gonna be helping with in community meetings and get that information out there, and it's an important piece to do that, to spread the word about that. We have, if you have not signed up to get your email into that list, please do so. Did everybody get a chance to sign in? Okay, we still need it. Adriana, did you have that? Great. We'll pass that back over this way. Some of those things that we'll make sure we will get out there include the link for the comment for the New York City that's allowing us to use that same link to get the comments into there. And to sign up for all of those types of things. We will also include, if we are able to get the phone number for tomorrow's phone call, and make sure that that information on there. If you have other people who want to check in and log in and hear what's being said, we can have that. We'll work with Irma and others, all of those on our board, or the panel here today, about the Q&A and the fact sheets that may be helpful that you can share with others in the community as well. And then lastly, I know that Sarah Davella from the Somerville Public Schools, they're going to be doing something for educators on Monday. Yep, Sarang will be there as well. That's wonderful. Thank you. Great choice. Although any of them would be wonderful. And that's going to be held at the administrative office, which is over at the Edgerly Center at 3 o'clock? 3:30. It's going to be 3:30 to 5. So if you would like, just check in with Sarah on some of those. I'm going to give everybody one last chance to ask a question, if that came up while we are here. If not, again, I want to thank everybody for taking the time to come out today to do this. And it's not just myself who are up here. Denise Taylor from our communications department did an amazing job pulling a lot of these things together and able to help us with the panel, as well as Nancy Solomon, Irma, and Adriana, and Jenny, and all of the other staff that were with Summer Viva. Thank you for all of that. We appreciate you taking the time out today to be here with us. There are some lunches left. Feel free to help yourself, and thank you. Have a great afternoon. Enjoy the weather, but let's mobilize. Let's stop this. Thank you, everybody.